Hello and welcome to the fourth Maritime London COVID-19 related webinar. This webinar is in partnership with Quadrant Chambers, and I would like to offer my thanks to Quadrant, in particular Sarah Longdon, who has worked exceptionally hard to deliver today's webinar. I'm Josh Standerwick, Chief Executive of Maritime London, and I'll be moderating today's session, which will explore how English law has responded to the COVID-19 crisis. In a market where there is scant good news around, one hopes this will be a story of pragmatism and ingenuity, as the maritime legal profession has moved quickly to maintain business as usual amidst the current travel restrictions. We have had a superb response to today's session, having just over 600 people registering, which I'm sure is largely down to the stellar participants, which include 2 Maritime London directors. So I best be on my best behaviour. Before we get started, I will run through the obligatory housekeeping notices. While we do not expect any tech issues, the world is fighting for bandwidth. So if we experience any issues, please bear with us. While we will do our best to minimize background noise, I will apologize in advance for any pet, children, or telephone related interruptions. If all goes well, recording will be made available after today's session. And lastly, but importantly, you will be able to ask questions in the Q&A box, and please note the chat function will not be available during this webinar. And to make my life a little easier, if you could indicate who the question is for, it would be greatly appreciated. Lastly, please note questions will not be answered by the panel until the presentations are finished. As mentioned, we're very fortunate to have 3 leading practitioners presenting today. Robert Thomas, QC of Quadrant Chambers, will review the formal guidance given by the courts as well as relevant decisions. He will also give his experience of remote hearings in this new era, including some practical tips as to how best to prepare and conduct such hearings. Ian Gaunt, President of the LMAA, will look at the rapid adoption of conference facilities for conducting LMAA hearings, and as such, the inherent advantage of ad hoc arbitration. He will also report on the LMAA working group established to give feedback on the conduct of remote hearings to understand the problems that the parties may be facing. Last but certainly not least, we have Mark Lloyd, partner at Kennedy's and chair of the Admiralty Solicitors Group, who will consider how practitioners in the service sector are working together to ensure that hearings, mediations, applications, and the myriad of logistical issues proceed, enabling parties to manage claims, disputes, and proceedings. Mark will continue to give his view on what the new normal may be and how the industry may choose to utilize the experiences from this period to benefit all moving forward. I will then invite comment from Rob and Ian about what their view may be in regards to the new normal, possibly ask a couple of questions myself before opening up the floor to questions. So without further ado, I will hand over to Rob. Rob, over to you. Thank you.
Good afternoon, everyone. As Joss has indicated, my focus will be on the approach to remote hearings adopted in the Commercial and Admiralty Court, on some of the issues that this raises, and on offering some practical tips as to how best to navigate them. Of course, some of this may be relevant to arbitration as much as to court work. But dealing very briefly at the outset with the legal framework for remote court hearings, the existing provisions of the Senior Courts Act as well as the CPR already provide the courts with wide powers to decide how and where to hold hearings, as well in case management matters more generally. That means that in the civil courts, at least in the UK, there hasn't been a need for widespread or sweeping reforms, and in fact, limited changes have been made. 2 perhaps bear brief mention at this stage. The first is that remote hearings do raise issues about public participation in those hearings. This has had to be addressed in the Coronavirus Act and in a new practice direction 51Y, which essentially clarifies the manner in which the court may exercise its discretion to conduct hearings remotely and in private. Of the other new practice directions, from a practical point of view, the one that is probably of most relevance is Practice Direction 51ZA. It permits agreed extensions of up to 56 days in place of the previous 28. and it confirms that the court will, so far as possible, take into account the impact of the pandemic when considering matters such as time extension applications, adjournment applications, and applications for relief from sanctions. However, rather more insight into the attitude of the courts can be found in the guidance that's been issued. And in this regard, it's fair to say that the UK courts have been quick off the mark. Even before the official lockdown, and as long ago as the 19th of March, the Lord Chief Justice issued a message applying to all civil courts. He explained that the default position from that stage on must be that all hearings should be conducted with one, more than one, or all participants attending remotely. In the same message, he emphasised that whilst there would inevitably be challenges, the courts would be embracing new technology to conduct business in the way that would have been, to use his words, unthinkable even a month ago. The same day saw the publication of the remote hearing protocol. Again, it reiterates the need to use remote hearings wherever possible. And whilst it emphasises that the decision must be for the judge in any given case, it does go on to say that it will normally be possible for all short interlocutory or non-witness applications to be heard remotely. Some witness cases will also be suitable for remote hearings, it says. So there's an unmistakable message that whilst it is a decision for the judge in any case, the courts will be expecting many hearings to go ahead remotely, and they will also expect the parties to embrace the use of new technologies, whatever the challenges. In fact, it didn't take long to find out how the Commercial and Admiralty Court would respond to this guidance. It was on the very same day that Mr. Justice Tier, in dismissing an application to adjourn a trial, observed that the Lord Chief Justice guidance was indeed clear, and he added, in light of it, it's incumbent on the parties to seek to arrange a remote hearing if at all possible. He continued that despite the obvious challenges, the court has to be optimistic rather than pessimistic. A similar approach was adopted by John Kimball QC, sitting as a deputy in the Insolvency and Companies list, where after detailed argument he refused to adjourn a 5-week trial which had been fixed for June, at least until there was a further PTR to consider the practical arrangements put in place for that trial. And in a yet further judgment on an arbitration appeal handed down just last week, Mr. Justice Butcher observed that the remote hearing was highly effective. Each counsel made, he said, focused, clear and helpful submissions, and he did not consider anything of significance was lost. So the Commercial and Admiralty Court has therefore signalled itself to be very much open for business, and with it seems an expectation that remote hearings will certainly be held for interlocutory matters and most probably for trials. A note of caution needs to be struck. In a judgment delivered last Thursday, the Court of Appeal, albeit in a family dispute, did issue a warning that the dynamics and demands of the remote process should not impinge on the fundamental principles. It emphasised that significant additional burdens were imposed by remote hearings and indicated that what it described as a hard-headed distinction may have to be made between those cases that are prioritised and others that must wait. In the same vein, the Lord Chief Justice has said last week that the courts may well have to reduce their lists by significant amounts to take into account the pressures created by the pandemic. And on the 1st of May, the Master of the Rolls announced a rapid consultation covering the entire court system, and which is due to report on the 22nd of May. So as with everything in the crisis, things are fast moving and further guidance will undoubtedly follow. Quite how it will impact on commercial business remains to be seen, but there's no reason to doubt that the continued willingness of the Commercial and Admiralty Court to proceed with business as normal will remain. So turning to practical issues, how are the courts dealing with these hearings? At interlocutory hearings, the court is currently only using Skype for Business, though there is apparently a separate platform to be rolled out sometime soon. What this means is that the system is administered and controlled by the courts, principally by the judge's clerk, who will, for instance, issue joining instructions. In the case of trials, where witnesses, experts and so forth may be called, as I've already mentioned, there will be a need for detailed consideration well in advance of what arrangements are appropriate to put in place. And indeed, there are a number of independent providers providing a panoply of service to allow this to happen. What is clear is that in all sorts of hearings, gone are paper bundles, and the new norm is the e-bundle. And what's clear from even this brief summary is that for any case, however straightforward, far more thought and preparation is required than we might be used to. An obvious but essential matter is the e-bundles that I've just referred to. They're required both for the documents and for authorities. They have to be got right, and everybody has to have the same thing. Now, the guidance issued so far is not prescriptive as to its form, but it does emphasise that the bundle should contain only documents and authorities that are essential to the remote hearing. And certainly in my experience so far, the judges can be significantly hampered by large electronic bundles. It's therefore obvious and important to give early consideration to the contents, to attempt to agree them well in advance, and then to create the appropriate bundles. It's also useful in my experience to agree, if possible, agendas and running orders, particularly for hearings such as CMCs, to minimise interruptions and to ensure everybody knows when they will be speaking. And in the context of pre-hearing issues, it's also worth mentioning time estimates. There is no doubt that remote hearings take longer, and there is equally no doubt there's nothing worse than a judge who feels time pressured. So some reappraisal needs to be given as to what is a realistic time estimate for any particular hearing. It's also important, in my view, to consider whether you adjust your approach to written advocacy in the terms of skeleton arguments. It's certainly my experience that with the electronic bundles, the judges are not reading around the key documents as much as they usually do. Whilst it's therefore important not to overburden a skeleton argument, I do think it's worth considering providing a slightly fuller written document than you might normally consider doing. On a somewhat more mundane but nonetheless equally important level, those with a speaking role need in advance to familiarise themselves with the e-bundles and how they navigate. Equally important is to work out what equipment you need and how you set it up. In that regard, I think everyone agrees that 2 monitors, 2 displays are essential, and ideally 2 computers, which means that one can be dedicated to the video feed. Likewise, work out where your camera is, work out whether the lighting works, and what will be seen behind you. Also, the use of a microphone such as this can help with clarity, especially if you're going to be turning around during the course of your delivery to look at documents or any other references. And importantly, work out well in advance how you're going to communicate with your team. It's almost inevitable that instructions will be required at some stage in almost any hearing. And whilst many platforms allow messaging, there is a risk of inadvertently broadcasting whilst you do so. In my view, an alternative good idea, something as simple as a WhatsApp group or indeed an email on a separate screen can be used. And finally, on that note, it's imperative you ensure, ideally the day before, that you can actually connect to the court system. There have been hitches, and I'm certainly aware of some Mac users finding it difficult to join onto the court website. So much for the preparation. What about the hearing? Well, briefly, The hearings do proceed, as I've said, more slowly than they might otherwise do. As I've said, it might also be fruitful to consider putting a fuller written argument in and saying less perhaps orally. In my experience, whatever approach you do adopt, it's important to slow down in your delivery. Sound quality is rarely as good online as it is face-to-face, and certainly if you speak too quickly, you can be physically inaudible. Likewise, allow enough time for the poor old judge to find the right page in that electronic bundle. Some are obviously better than others, but all of them, in my experience, take more time to navigate around e-bundles. And it's easy to say, more difficult to achieve, but please don't shout, which is the temptation when you're speaking at a screen. And likewise, I think it's more important than normal not to interrupt. Speaking over somebody on a remote link usually means nobody can be heard at all. It means everybody has to stop and back up and causes a degree of frustration. So those are just a few of the pointers, certainly some of the things that have occurred to me in my experience. But plainly, if you're involved in a full trial, there will be a whole host of other issues which will need to be considered both in advance and during the course of the hearing. Location of witnesses, access to documents. How do you ensure that witnesses are not being assisted? How do you effectively cross-examine by video? Those are all important questions, but time has defeated me. I think I've already passed my allotted slot. So on that note, I'll pass over to Ian Gaunt, who will give you an overview of the approach in London Maritime arbitration.
Thank you very much indeed, Rob. Good afternoon, ladies and gentlemen. It's a great pleasure to take part in this webinar. And I could start really by echoing a great deal of what Robert has already said about the conduct of proceedings in court by virtual means, because many of those points equally apply to arbitration. As far as we're concerned in maritime arbitration in London, much of our activity is business as usual. And I think despite the very unusual circumstances we find ourselves in, it's worth remembering that 80% of London arbitration cases, in maritime cases at any rate, are done on documents only, so that the questions and the problems which arise in the case of virtual hearings don't arise at all. And this is a position which is, I think, in contrast with many other arbitrations conducted, for example, by institutions, because a much greater proportion of their cases, if not all of them, do require hearings, and many of them have been scrambling around to see whether their rules actually permit them to conduct either virtual hearings or to deal with cases on paper. In the LMAA, which is probably the archetype of ad hoc arbitration, a very flexible form of arbitration, we have looked at our rules, obviously, and we are quite satisfied that we do have the ability to conduct virtual hearings. And of course, we have the ability, as we've always done, to conduct cases on paper, which of course relieves a great deal of the pressure. We have for a long time been conducting semi-virtual hearings. Only just before the lockdown, I, together with Simon Gold, who may be listening on the call, were involved in a 4-week hearing where all the witness evidence, at any rate, all the evidence of fact, was heard by video conference. And from places like Hong Kong, Bangkok, Mumbai, and elsewhere. And it was perfectly satisfactory. The connections remained completely effective, and we really had virtually no downtime at all. Following, of course, a very comprehensive rehearsal, and that is a point I think which Rob has already made, that you don't go into this in the way in which you would simply enter a normal hearing room. You really do have to make sure that the IT is working properly and that everybody is prepared to conduct a virtual hearing in a thoroughly efficient manner. As far as the LMAA is concerned, we have tried to encourage our arbitrators and parties involved in arbitration hearings, which were set up during the early part of the lockdown, not just as a matter of course to kick them into long grass and to postpone them. We have tried as far as possible to encourage the parties and our co-arbitrators to have virtual hearings where necessary, including virtual CMCs, and to familiarize themselves as quickly as possible with the conferencing facilities which are available. Many people, for these purposes, outside the courts, we've heard that the courts generally use Skype for business with variable results. Much of the activity in arbitration has been on Zoom, as this call effectively is today. And we've been trying within the LMAA to make sure that all our arbitrators are familiar with the way to conduct a Zoom meeting, including, for example, putting parties into separate rooms whilst the arbitrators debate, or when the parties want to debate amongst themselves. And we have been starting a system of Zoom training, which we will try to roll out also to the supporting membership. There have been concerns, obviously, about Zoom. All of you have been heard in the press about some of the security issues which have been raised. We feel that in some cases these have been rather overstated. It's clear that people like Elon Musk in transferring trade secrets, or NASA and so on and so forth, are very reluctant to find their material in the hands of the servers in China, but we're not necessarily in that position. At the same time, we have to be cautious. Meetings have to be protected with passwords, and a level of security has to be maintained, and the parties have to agree that they understand the level of security which is implicit in Zoom. But Zoom, of course, is not the only game in town. There are many other systems which are available at the moment. The IDRC, for example, tends to use a system called Blue Jeans. We also know that Cisco WebEx is quite extensively used. But perhaps a point to make is that once people are well trained and well familiar with Zoom, they're likely to find the functionality of the other systems quite easy to master. And it's likely to be able to be possible to switch over from one system to another without too much difficulty. As far as the hearings are concerned, obviously in arbitration, party autonomy rules subject to the directions given by the arbitration tribunal, and we have a very high degree of flexibility as to how the hearing takes place. But in many respects, the hearing will be substantially the same as a physical hearing. As Rob has said, a great deal more attention has to be paid, however, to the handling of documents, and particularly to the preparation of e-bundles. Many of the objections which I've heard to virtual hearings so far have been on the basis that people have not been able to get into their offices, and therefore have not been able to get hold of physical documents, and therefore to scan them, form PDF bundles and so on. So one has to have a measure of consideration for this, but nevertheless, in most cases, documents will be held already electronically, and it's a question of drawing those documents together and making sure that they are properly indexed and can be easily called up in the course of the hearing. Now, in the cases I have been involved with so far, we've seen a wide spectrum of approaches to this. One approach at one extreme is to involve organizations and providers such as Opus 2, with whom many of you will be familiar, who will handle the whole of the documentary process, handle the whole of the internet connectivity, together with probably the IDRC. And it's an all singing, all dancing affair where the arbitrators really have to do relatively little more than they would have to do in a perfectly normal hearing. But so those types of facilities are probably not suitable for every maritime arbitration unless there's a fairly substantial sum involved or the hearing is going to be a long one. At the other extreme, you have cases where the whole of the process, including IT, is handled either by the arbitrators or the arbitrators in conjunction with the parties, and the management of the documents and the management of the process is handled by the arbitrators. Backup is extremely important. What happens if your line goes down? Obviously, internet connections are now much more reliable than they were in the past, but glitches do happen. It would be wise, for example, to have backup by way of 4G connection, as we've experienced, in fact, today. It's important that there is control over the process of management of the hearing, more so than in a normal hearing. It has to be much more concentrated. There is less time for banter and for downtime. And that degree of concentration also imposes a burden on the arbitrators, no doubt on counsel, so that it will be preferable to have shorter hearing days and more breaks than we would normally have. It's essential to have a practice a day or so before the hearing to make sure that all the IT is up and running properly and that everybody is familiar with it. Well, what are we doing else in the LMAA to facilitate this and to make sure that we remain ahead of the game? One thing which we've done is to set up an IT working group to examine the facilities which are available for holding remote hearings, and to use that as a kind of sounding board for those involved in remote hearings to feed back their experiences to the working group, so that we can take account and we can advise arbitrators, LMA arbitrators, of the problems which the parties may be facing, and to generally streamline and make more efficient the conduct of remote hearings. We're also taking account of the regime in the courts and how that is working out. And that so far has been extremely useful, in addition to which we're providing basic training on Zoom to make sure that arbitrators are not going into a hearing and say, oh, how do we do this? We can't cope with it, and so on and so forth, so that we have a thoroughly efficient process. So this is how it is working. It is flexible, as arbitration, particularly ad hoc arbitration, is flexible. And does it work? The answer is undoubtedly it does. It won't work in every case, perhaps, but for the vast majority of cases that we are concerned with, we can make it work. What will happen in future? Mark, I think, is going to touch on that as well. We think it will continue. The parties, having familiarized themselves with the use of electronic bundles, will continue to use them in future and rely much less heavily on hard copy bundles, which will be very music to the ears of the green arbitrators, I think. But there will undoubtedly, as in every walk of life as a result of this crisis, be things which we will learn in the course of this process, which we will undoubtedly want to adopt in future, and hopefully in making arbitration in London ever more efficient. Thank you.
Ian, thank you so much for that. And just taking some of Robert's advice, we have a WhatsApp group running in the background here, and I've been asked on that whether we can remind everyone to use the Q&A function on the bar at the bottom of your screen in order to ask questions. So hopefully that will work very well, and we'll move to questions after Mark talks about how the solicitors and the ASG are working in this brave new world. So Mark, over to you.
Thank you, Josh. Thank you, Rob. Thank you, Ian. Well, the new norm is me putting on a shirt and having a shave after 6 weeks of being at home. But what I think is clear from what Rob and Ian have said is that this new lockdown COVID system is working. And as solicitors, users of both court and arbitration, we have for many years been in a cooperative way of working together so far as possible. And before lockdown, as the Admiralty Solicitors Group, we set up a WhatsApp group to ensure that we could communicate on issues such as new rules, any issues that the firms found, and how best to work through tech and hearing issues. Thankfully, we've not needed to use that group too much because the system has been working. What we have also seen is that ADR is coping in this brave new world. Mediations globally are working online. And I've heard from our office of a case in the US where 55 lawyers have managed to work out a mediation online. You can have a password and encryption. The mediator can control the mediation room, and each party will have its own breakout remote room. Now, the difficulty on that, as Rob has alluded to, is ensuring that the tech is there and every party has that accessible. Thankfully, again, so far, that seems to be working smoothly. There were some glitches in the early days with Zoom, with sound, with video, but as we move through this period globally of lockdown, the parties and the users of the services seem to be getting used to that. And we have not heard of any major difficulties as long as you prepare and plan for this new brave world. It is also worth remembering that in the UK, the fundamental underlying position is that there must be just dispute resolution. The parties are expected to be honest and transparent and to work in a cooperative way. There is case law from as far back as 2014 talking about no opportunism when there are circumstances that a party could choose to maximise benefits. Technical points on time extensions are unlikely to be looked upon favourably by the courts if it is affected due to the COVID pandemic. Therefore, the parties are expected and have been working very closely together to ensure that the system works smoothly, that, for example, if time extensions are requested, if there is difficulties because of communication, that there is honest and transparent communication. We have seen good engagement on that from both insurers, the P&I clubs, the solicitors, and the way that we work together with the bar, arbitrators, mediators, and the court. There are some practicalities, as Rob and Ian have both alluded to. Those are what need to be worked through in advance. And I think most users of litigation services in the UK are already working on paperless or paper-light office systems. In the UK, e-disclosure is very much now the norm, and there are very substantial providers who are working and assist parties on how that is managed. I will come on to this in the new norm, but as Ian has alluded to, I think those type of providers will start to take very much more of an active role in document management and the way that hearings and litigation is perhaps conducted. What is clear, I think, is that for lower value claims, the remote or no hearing model is something that has been worked on and planned for many years. The Lloyd's open form system of the fast and low cost arbitration and the low value claims is a prime example. Parties have been working on document light, no hearing resolution of disputes for many years. The simple issue that we have at the moment is the added practical issues that arise because of the lockdown, and as Ian mentioned, the fact that the parties cannot perhaps get into their office to get at documents. Again, I will come on to this with thoughts for the new norm, but when lockdown restrictions have been eased and parties and users are able to access their office, a lot of the difficulties in the planning and preparation for remote hearings or video hearings can perhaps be managed far more easily. So the new norm will invariably mean that these systems will be developed and used more widely. There are a number of challenges now for how parties work together. Ian, Rob, and Joss have alluded to this. The tech. Not all parties, when the lockdown happened in the UK at least, were set up to be able to work from home, to have two screens, to have the ability to deal with e-bundles. Very quickly, if companies and law firms or barrister chambers had not got those systems in place, they were put in place quickly. And it is now fairly obvious from the way that the system has been working that claims handlers at insurance companies, barristers, solicitors, P&I club handlers have the ability to work from home more regularly and to have the tech there to deal with, for example, the way this webinar is working with up to perhaps 650 people. So the new norm. I think we have to consider period of lockdown and then post-lockdown. the lockdown period is being released, will remain in place in various territories globally for different periods of time. I think most discussions seem to think that lockdown and social distancing and access to offices will impact various countries, various offices, until probably the end of the year. Various countries are coming back online with lockdown restrictions being eased far sooner than that, and we wait to see when the UK will ease its lockdown and working from the office-based environment will become the revised new norm. So, hearings seem to be working now. Mediation seems to be working now. What we have to cater for in the lockdown period is very large hearings or trials or arbitrations. And as Ian has said, they have been managing to go ahead. A major commercial court trial of maybe 3 months, that would be a struggle if you have multiple witnesses and experts in multiple jurisdictions. But the systems are there to be able to work that through. For the English courts and English arbitration, hopefully that will not be a factor for too much longer, although social distancing will remain in place. So the new norm after lockdown is, I think, where we need to consider what lessons we have learned and where we will move to next. In my view, I think it is clear that remote hearings will be required and supported by both arbitrators and the courts if the parties are prepared to and will develop those initiatives. There will inevitably be revisions to the CPR. There will inevitably also be revisions to various insurance contracts and provisions as to the way insurers wish to deal with litigation and dispute resolution. A major factor for insurers and users in particular will be whether there are cost savings in dealing with matters remotely. There clearly will be some benefit in cost reduction, even if you just look at travel. But as Ian and Rob have already flagged, at present, the costs involved in preparing for a remote hearing, the rehearsals, the tech, the perhaps increased length of hearings because hearing days will be shorter, will have an impact. That cost reduction will not perhaps be as large as some parties would presume. But that will develop and costs will inevitably be saved as we deal with remote hearings and applications. In the UK, there is also a major driver that for justice, there must be the ability for public access. In major admiralty and commercial disputes, that is less of a driver, but it will have an impact on the way that government, Department of Justice, and the courts will look to deal with remote hearings and equanimity of parties' bargaining power or litigation ability to conduct litigation online and remotely. The rules for the Admiralty and the Commercial Court can be developed relatively quickly, and Mr. Justice Tier, as the Admiralty Judge, has been very keen on developing that together with the Department of Justice for removing obstacles to dealing with maritime matters very quickly and very promptly. A prime example is the way that the collision rules were adapted to allow for tech and electronic charts. So how will we be doing business in litigation in the next 6 months, 12 months, 18 months, 5, 10 years? It is fairly clear to me that tech is here, it is here to stay, and that we have managed to get through the challenges, and therefore we can expect that there will be more involvement of this sort of technology. There will be development of the providers. There will be addressing of issues such as the concern over Zoom and its security. There will need to be consideration as to when the releasing of certain regulatory requirements, either by regulators of the legal profession or in a wider sphere, will remain relaxed or in place. For example, at present, the Law Society and the regulator of solicitors has been very keen to ensure that there is an element of relaxing the element that data is allowed to be taken home by solicitors to work on files rather than having to be kept in the office. But data protection and confidentiality will remain a major factor. encryption of Zoom, password, ability and access are ways to get around that and protect in particular the confidentiality of arbitration. E-disclosure. Ian has already alluded to the fact that some providers of systems of documentary management are assisting in taking over the ability to do remote hearings, including fixing and hosting the arbitration. Document management providers will clearly enter a growth phase, and they will offer a inevitably developing option for parties to utilize them for both document management during the progression of litigation and thereafter for any hearings, arbitrations or mediations. You can see the development of those, and I know Ian's mentioned Opus 2. That is going to be more and more of our day-to-day, perhaps, development of where and how litigation will be managed. I think it is also inevitable that virtually all clients and users will be moving paper light, and there is going to be an inevitable, I think, knock-on effect as to how many clients, how many users have so many people office-based as they currently do. That is a wider social issue, I think, but how many companies will continue to have the number of people that they do based in a single office, say in Shanghai or London or Bristol? The ability to work from home, once the tech is there, is going to be a major factor that we can all utilize. There are also pressures on court buildings and staff globally. And so the ability for having remote hearings when there are less court buildings will be a factor that government and the DOJ will be keen to develop. But there is no guarantee that the current situation with the relaxed regulation will remain in place after lockdown. What is clear is that the working group that the LMAA have set up, the discussion with the CPR working groups will lead to some changes, and they will end up, in my view, leading to, ultimately, tech becoming far more of our day-to-day lives. And I think we all have to accept that, we have to get used to it, and we have to be able to ensure that perhaps the spend for both the users and the providers of services on how they do their day-to-day work will be on tech and the associated equipment to enable this new way of working to continue. And Josh, I think that's really my thoughts. And so subject to anything Ian and Rob or you have, that's just some thoughts on the new norm.
Perfect. Thanks so much for that, Mark. I think after that relatively unambiguous view of the future and the increased application of technology, it's worth inviting back Robert and Ian to give their views as to what the new normal may look like as we come out of this pandemic and start to look towards the recovery. So, Rob, I'll pass over to you.
Thanks, Joss. I have to say, I've given up making predictions in the current climate, but I certainly think that we've all learned quite a lot and becoming rapidly more comfortable with some of the technological developments. I think the fact that the courts will have worked remotely will make them much more prepared to use the technology in appropriate cases. I don't see a lot more remote hearings once the pandemic's over, but I do see a greater use of video technology with witnesses and so forth. It's obviously been part of the environment for a while, but it's always been a rather reticent judge who allows video cross-examination. I think, for instance, that may well see a significant increase. Beyond that, I'm certainly not laying any money on any particular outcome.
It's clear that document management is going to change, and the old-fashioned way of dealing with documents by hard copy bundles, which are produced in numerous copies for every member of the tribunal, plus counsel, solicitors, witnesses, and so on, is going gradually to be phased out, or at any rate, the document bundle, which is going to be referred to in hard copy, is going to be very, very much slimmed down. And I think that's no bad thing. But on the other hand, it does mean that a great deal more attention is going to have to be paid to, at an earlier stage, to what documents are actually going to be relevant, what documents counsel is going to want to refer to in cross-examination and so on. So it will result in changes in the way in which preparation is done, as I think Rob has already said. The cross-examination of witnesses, I think, will change too, because I think the days when one would draw up a wish list of witnesses who can be persuaded to fly halfway across the world for what ends up being about 15 minutes cross-examination are probably over. There is no reason for it, in my opinion, unless you're dealing with a witness whose credibility, fundamental credibility, may be in issue, and you want to see by their body language how they react to questions under cross-examination. But frankly, you can see that by video anyway, for the most part, or by the answers that they give to the questions. And taking evidence in an arbitration by video link is, in my view, a very satisfactory way to go in the vast majority of cases. And I think this point was actually made in a Quadrant newsletter quite recently on the Quadrant web, that the necessity to eyeball witnesses and put the fear of God into them by being present in the same room is not necessarily going to be make a huge amount of impression on the arbitrators or the outcome of the case. So I do think that more and more witness evidence will be taken in this way. There will undoubtedly be other consequences too. I don't think that we will be going to 100% remote hearings after the lockdown, but there may be some partial solutions, particularly for case management conferences, for example. It may be much less necessary for all the parties to get together in the same room. So those are some thoughts about where we're going to go.
Ian, thank you for that. As if by magic, our panelists must be well used to making online representations, because we've timed all of that perfectly. And we've got 10 minutes left for questions. We've got quite a few come in. To save a bit of time, Robert, you're probably best placed to answer the first two from Denise and Christina. So perhaps I can pass over to you.
Sure. Thanks, Joss. The first question, certainly in court, is easy. The proceedings are recorded by the court, and on one case, I've had a transcriber also present by video link, and that worked very much in the usual way. It's worth observing that Section 85B of the Coronavirus Act makes it an offence to make an unauthorised recording. So certainly in court proceedings, you need to leave it to the court to make the recording, and you can get a transcript in the usual way. With regard to the second question about how do you assure that witnesses will not be assisted by lawyers, this is an issue that arises obviously in any case where there is a video cross-examination or video attendance. I think the answer lies in the point I made about having to put in place appropriate measures and arrangements well before the trial. It's going to depend on obviously the restrictions in place in the location where the witness is found. For instance, in the UK, certainly as we read it, it's not unlawful or against the law to, for instance, go to a solicitor's office and sit in a room if there's appropriate social distancing and it's deemed necessary. So in countries where there is some freedom of movement, it may well be that some precaution can be put in place. I also understand there's technological solutions. There's 360 cameras which apparently can see the whole room, so you can use those, but it's certainly a matter that obviously needs careful consideration when you put in place the arrangements for whatever trial you're attending.
Thanks for that, Rob. We've got one here from Andrew Stevens from 4 Pump Court. This is for Ian. Ian, in non-Opus 2 managed bundles, what doesn't work in terms of ad hoc e-bundles?
Well, I will be able to tell you that better when I've been through the process of 2 remote hearings, which are coming up next week. But from previous cases where we have relied on electronic bundles, I would say that it's a matter of finding the document, that it can take time to bring a document up and make sure that everybody is looking at the same document. This is, I think, really one of the joys of being spoiled by Opus 2, that council can call for a document to be put on the screen, and in no time at all it's up there, and you will be able to also scroll between the previous document and the next page and so on. Where you're dealing with electronic bundles yourself, either you've got to have, I think, somebody who's a third party from the what represented one of the parties who is managing the display of the documents, has access to a well drawn up index and can produce the documents quickly. Otherwise it will slow the whole process down. Another point which I think is worth making is that where you're taking remote witness evidence, as Andrew himself will have experienced, it's essential that the witnesses in the remote location have the same e-bundle facilities and can be looking at the same document in real time as the tribunal. We had a tribunal who were all in the same room in the case I'm thinking of, but the witnesses were in a wide variety of locations, and in fact in that case Opus 2 arranged for the equipment to be shipped out to the relevant locations at very short notice, in fact, shipped through customs where necessary also, but in fact, if necessary, these documents can be made available electronically using a normal laptop too. But it is very helpful because the witnesses are not then scrambling around with the assistance of another third party who has to be in the room to find the relevant place in the hard copy bundle which they need to look at. And my experience, that worked really particularly well in the case of cross-examination of witnesses and saved really quite a lot of time.
Shailendra has asked an interesting question, which perhaps can be widened out a bit more broadly here. But she's asking about, in terms of the lockdown, when parties in an arbitration can't access physical documents and have asked for an extension in terms of serving the submissions, can the tribunal pass a preemptory order asking the party to serve their submissions? And I suppose this also links back to, particularly in terms of an arbitration, how do the parties agree on having remote hearings in general?
Well, in the current situation we're faced with, we're mostly dealing with hearings which were already scheduled to have taken place during the lockdown period, and therefore we're trying to improvise and work around hearings which are already fixed, and to decide whether those hearings can go ahead, either, well, clearly remotely if they're going to go ahead at all in the immediate future, or whether we've got to postpone them in some cases by several months in order to be able to do that. The first point is that there is a reluctance to do that. Our reluctance is similar to the reluctance of the courts, but we don't have the same preemptive powers or prescriptive powers that the courts have to say to the parties, you're going to do it this way. Nevertheless, I think by understanding better, and the arbitrators are expected to do this, to understand what the parties' real difficulties are, because I'm afraid to say that I have had the experience that in some circumstances people have simply been invoking the lockdown to introduce delays when there have not really been serious attempts to find ways around it. On the other hand, to deal with the specific question, where documents are simply inaccessible, it seems to me that it would be potentially unfair to require a party to produce those if they simply can't be accessed in these circumstances, and the tribunal ought perhaps to have some sympathy with the inability of the party to produce them at that moment in time, if indeed they have to be produced in order to enable a case to be pleaded. Obviously the case might be pleaded provisionally, subject to the production of those documents, because under our system you do have to produce the documents, generally speaking, with the submissions, but the tribunal should then be sympathetic at a later stage to allowing amendments which might need to be to reflect the contents of the documents which couldn't be accessed at the time the application was made.
Thank you for that, Ian. We've got one here from an anonymous attendee, and I think the panelists largely answered this, but it could be worth re-emphasising in terms of how do you think the possibility that remote hearings and trials will be practicable in the long run after the pandemic, so that in the future people may prefer such an alternative of online hearing or trial of cases, since it is a more cost-effective and potentially flexible option? And Rob and Mark, perhaps you want to start off on that one.
Joss, yes, very briefly, I think I've already made some points on that. I'm not sure that the physical location of the lawyers and arbitrators and judges is that significant in cost terms. Certainly for us, we don't have to go very far. I think the impact is more likely to be important where the witnesses are abroad, or possibly the legal representatives of one party are abroad, and obviously that's going to be an issue in arbitration, not in court work. I do feel that certainly the judges and most of the arbitrators will probably wish to and find it easier to see the lawyers in front of them physically. And I would have thought, Ian may disagree, but I would have thought the real savings here are particularly in relation to documents and foreign witnesses who are otherwise required to attend for a very short cross-examination. I think that's where the real changes are likely to be found.
Mark, have you got anything to add there?
Thanks, Joss. No, I'd agree with Rob. I think the major savings will be on documents. And if one party wished to have a remote hearing and the other party in a two-party dispute did not, then in an arbitration that would be a matter for the arbitrator to determine on the basis of submissions, and the same for the court. I think if one party insisted on a physical hearing, they would need to make the case as to why they expected everyone to travel. Again, depends on the tribunal, but more often than not, I would imagine, particularly in the consensual process that is arbitration, the arbitrators are more likely to side with if a party insists that they would be minded to insist on a physical arbitration. But yes, I mean, there are going to be examples where one party may wish not to and another party may. Hopefully the parties' representatives could agree at the procedure rather than having to trouble the tribunal, but that is not always the case.
Yeah, I mean, as arbitrators, we've got to do, under Section 33 of the Arbitration Act, we've got to balance two things. One is to devise an efficient, that means equally time efficient and cost efficient means of resolving the dispute. And indeed, remote facilities may well form an important element in that balancing act. The other thing which we have to do is to give the parties a proper opportunity to state their case, develop their case, and we have to be satisfied, therefore, that the way in which a virtual hearing is going to be conducted does enable them to do that. But I think that those tests could quite readily be met in many cases in future. I think one difference between the courts and arbitration in future is that the courts are, of course, expected to be public. And one of the issues which the courts had to address when deciding on virtual hearings was how do they admit the public to the hearings when they're being held virtually online. And various ways have been found to convince everybody that the public do really have access to court proceedings. Now, of course, arbitration proceedings, hearings are private to the parties. We don't have to consider giving the public access, and indeed the public don't have access to an arbitration hearing. So it is conceivable that there might be more virtual arbitration hearings, perhaps particularly where there is a sole arbitrator involved, than will be the case with court proceedings. But we will have to see how things go. But what we do know is that this facility is available, and we know that it can be made to work.
Right, we're now just running over our allotted time limit, but I think we can fit in one more question, and we'll ask this first to Ian, but then perhaps open it out as well. And this is from Sean O'Sullivan at QC, and it's a very practical COVID-19 related question, I suppose. And he's asking, to what extent have arbitrators made significant changes to the sitting day to take into account flexibility when it comes to lawyers and witnesses in different time zones, or of course having to take on childcare responsibilities due to the fact that their spouses may be key workers or whatever else. Yes, so that is a question for Ian to begin with, but maybe Mark and Robert would like to comment too.
Well, I suspect that there's not a great deal of experience so far which one can would enable one to generalize. I can really only speak from perhaps my own perspective, my own attitude to this, and I have been involved in hearings where there have been extensive witness evidence has been given, for example, from China, where witnesses are ending up giving evidence in the middle of the night, their time, and so on. My position is that arbitrators have to be flexible. If that means sitting at 7 o'clock in the morning to accommodate the parties, then I would be prepared to do that if there is a good reason for it. And similarly at the end of the day. In terms of childcare, it's not actually been, I've not had any applications made in terms of scheduling to accommodate that, but it's not unreasonable, provided that the parties agree to it, or that they have a sort of an equal amount of advantage and downside to them in handling a hearing. I mean, obviously there has to be a core part of the day which has to be devoted to the hearing. I think, as I said earlier, though, that the degree of concentration which is required in handling virtual hearings is such that the hearing days will have to be at least slightly shorter, and we will have to have breaks instead of having an hour and a half breaks to accommodate principally the shorthand writers, then probably to go for not more than an hour without a break of 5 or 10 minutes or so. But I think arbitrators have to be flexible as far as possible, and as far as it's reasonable to accommodate the parties and their counsel and those involved in the case.
Thanks. Does Robert and Mark have any further comments to make there about, providing some additional flexibility during these current times?
Joss, no, I would just echo what Ian has said. I think that if the parties need that flexibility, subject, of course, if a hearing has, say, been set down for 4 days, if there were applications made that meant that hearing then had to be split, held over, and then come back again in a few months, that would be a factor in consideration of those sort of applications. But invariably, if an application is made with good basis for shorter days, or flexibility because of the witnesses or the advocates, I'm sure most arbitrators would be more than willing to accommodate the parties.
Thanks for that, Mark. Well, listen, we are 5 minutes over time, so we should probably look to bring proceedings to a close. And apologies, we've had over 20 questions now, and we haven't been able to answer all of them, but it shows that it's been a popular and well-received seminar. I'd like to thank all of the panelists who have taken a lot of time to prepare for this out of their busy diary, and of course Quadrant, who have done a lot of the organising behind the scenes. I think it's been a great success. So thank you to you all. Thank you very much for your time. It's been a great pleasure being here this afternoon, and I wish you all a very nice rest of the day. Thank you very much.